Number 1, Forman versus Henkin. Counsel.
May it please the court, Michael Bono, Wade Clark Cahey, on behalf of defendant appellant Mark Henkin. Your Honor, may I reserve 2 minutes for rebuttal, please?
Yes, sir, you may.
If someone showed up at a discovery conference and said that they were not going to turn over photographs because they were in a box in their closet marked private, the clerk or the judge would probably have a good laugh. But because Facebook is involved with this matter, we are here today before the Court of Appeals in a simple discovery dispute in a personal injury case.
Counsel, if we were to agree that the courts below were too restrictive in their approach, do you agree that we are limited, based on the procedural posture of this case, to the relief we can grant here?
No, I don't believe so, Your Honor. I think that the order that Judge Billings issued could be enforced if the standard was not such that the only way to establish a factual predicate was via the public Facebook page. I think if the court held that targeted demands toward specific allegations made Facebook postings from the private side disclosable, then I think that Judge Billings' order could be enforced.
But I guess the question is, could we change that order or order it or reconsider, ask that the court send it back for reconsideration of the order so that it could potentially be expanded or revised?
That would certainly be an option. I think, as I said, I think it's capable of being enforced.
Well, how do you get to that? I mean, what's the standard of review? I mean, are we looking at whether the appellate division abused this discretion, or are we looking at whether the Supreme Court abused this discretion? And how do you send it back to the Supreme Court if we're just looking at what the appellate division did?
Well, I don't think it would be necessary to send it back to the Supreme Court, because I think the discretion that was abused was the appellate division. So, consistent with that, as I indicated, I think the order is capable of being enforced as written, because I don't think anything that Judge Billings did.
In fact, you didn't appeal that order.
I'm sorry?
You didn't file a cross appeal of that order.
No, we did not.
Right. So essentially, you're not aggrieved by that order.
No, I would like it to be a little bit different, but you're right. We did not appeal that, and we believe, because it's targeted and specific, that it's enforceable and should be enforced.
Well, you would agree, though, that your discovery request was not so targeted and specific. It was pretty broad.
Yes.
So could we, since we're talking about remedy, could we affirm based on what the discovery request was, but permit you to file a new, more targeted discovery request?
Well, I think what's operative at this point and what replaced our discovery request is the court's order. Discovery conferences, motions and the like tend to sort of be organic in the way they develop. And certain things are requested, certain arguments are advanced, and the judge at the end of it issued the order, and I think that's what currently stands.
What's the procedural posture of the case now in Supreme? What's happening?
It is currently continuing with certain depositions that were there were additional injuries that have been asserted, and we're seeking discovery based on those additional injuries.
Has your position at all changed? But, and I'm not a Facebook user, so, and I would advise all judges probably not to be, but that's for another day. But anyway, is there a distinction that needs to be made between messages, which I'm assuming are written messages, and posts, which are like a photograph that you post on a Facebook page? And in a remedy, would we need to address anything like that?
Well, I think there is a distinction between messages which are sent to one individual and posts which are posted to the entire framework of Facebook friends. Mm-hmm. And in this circumstance, I think the judge was careful in that the order was limited to number of characters and number of posts or messages.
Why do you think
So-
there's a distinction in terms of discoverability under 3101?
Well, because I think a better argument can be made that a message sent to one individual is not the same as a post made to all of the friends,
But
because
not-
there's
not
no
the
privacy
same- But not the same
expectation.
for the purpose of thinking about a protective order, or not the same for the purpose about thinking whether it's likely to lead to the discovery of admissible evidence?
More towards the protective order side. I think they would both go towards, they certainly could both produce material evidence.
Well, for example, a private diary, that isn't meant to go to anybody, but it may be discoverable, right?
Absolutely.
So how does this relate to that situation?
Well, I think it's based on what was said in this case insofar as usage of Facebook and the like. I think in a in a diary type case, it would depend on what was discussed in respect of how the diary was used and the like. So I think for that reason,
I mean, the box of photographs you started your argument with wasn't going to anyone.
right.
And I take it you were saying that that's discoverable under 3101.
Depending on what was said in respect of how the person
What they're
took
photographs
photographs.
of and what the underlying cause of action was.
But that would apply to photographs in any setting.
Yes.
So, hard copies or digital copies, so that really wouldn't make a difference. See, the problem with messages is, if you get into drawing a distinction from messages that's different from emails or a hard copy or anything else, then once again, you're saying the nature of the medium is going to determine your right to discovery. And in some ways, most of the judges, most of us have done some commercial or certainly any PI work that involves large amounts of medical documents. Usually the attorneys themselves sit down and go through them and say, these are the 5 that are still in dispute among us after we do this. I think eventually with this kind of situation in digital discovery, we're going to be doing the same thing, where the attorneys are going to pinpoint those problem areas ahead of time, and then the case law will then develop around those pinpointed areas. And this may be the beginning of that.
Yes, and I think a better argument can be advanced in respect to messages as opposed to posts. But I would argue under this circumstance, they should both be discoverable.
Let me ask you this. Under the rule that you're advocating, what is not discoverable, given liberal discovery? What's not
I don't
discoverable?
think that simply because someone has a Facebook account, a litigant is entitled to access to it just because they file a personal injury suit. And I also think that general allegations aren't enough to trigger access to it. But I think like in this circumstance, where there's a traumatic brain injury, where part of the allegations go towards the inability to use Facebook, for example, it should be discoverable, again, when it's targeted to specific allegations made.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, may it please the court. Kenneth Gorman on behalf of Pollock, Isaac, and DeSico for the plaintiff. Well, according to the defendant's logic, the mere possession of a Facebook account provides a sufficient basis to compel a plaintiff to provide.
Well, you just said that's not the rule. You just
That's
said
correct.
that that's not the rule. So what's the rule you're advocating?
Well, the rule I'm advocating is traditional discovery principles, which has been applied all across the board. A factual predicate by identifying relevant information that contradicts or conflicts with the plaintiff's alleged injuries, and it has to be narrowly tailored so that the information relates to the claimed injuries from the accident. And none of those prongs were met in this case.
Is there any other context, though, in which, and I think this is what you're advocating, correct me if I'm wrong, in which you have to essentially come up with proof from the very source that you're seeking access to in order to get access to that? Is there any other context?
I don't think so. I know that the appellate division alluded to that, but I don't think that's correct. I think you can get proof from any source.
Okay.
It could be
What's inadequate about the proof here? Where, it seems to me that the plaintiff's testimony was pretty specific about her pre-accident and post-accident use of Facebook, and what she could and could not do. So what more would the defendant need to have done to make it an appropriate discovery request?
Well, when I read her testimony, I took it to mean that her social life was severely hampered or restricted as a result of the injury she sustained. I don't necessarily think it was specifically limited to Facebook itself, but her.
Well, it may not have been limited, but she specifically talked, I think, about her ability to post things, to read messages, to create messages, or I don't know if we're talking about messages or posts. I'm using those words interchangeably. I realize that may not be accurate, but I think you get the gist of it.
So are we talking about her ability to socialize or her ability to actually compose messages itself?
Well, I think all of those things go to her ability to socialize. She said, I'm isolated now because this is what I used to do and I can't do this anymore. So it seems to me that if the goal is to show that indeed she was able to do it because she did do it, that, you know, that's exactly what we traditionally look for in terms of discovery requests.
Okay, I mean, under those circumstances, Giacchetto versus Patchogue, where they basically stated that under those circumstances, I mean, I don't know if the court has jurisdiction to actually do this, but if the court really felt that there was evidence or the possibility of evidence, the plaintiff's attorney would conduct his own inspection and produce the relevant evidence. But that wasn't the case here because he never requested it. And I don't know if the court would have jurisdiction to do it because it's not preserved.
Can I
thought that-
ask, what have you turned over? Did you review the Facebook pages yourself?
I'm not the trial attorney, I didn't
I'm
review
sorry,
it.
did the trial attorney do so? Do you know?
No, I don't. I don't know if the
What,
trial.
if anything, has been turned over?
From Facebook.
Yes.
I don't think anything's been turned over from Facebook. So, I mean, under these circumstances, the same rules apply to Facebook as any other
Isn't that
request.
really the question? It seems the First Department has created case law that says there's a threshold requirement, and that there is no threshold requirement for the exact same picture, let's just stick with photographs, in a non-digital setting. In a non-digital setting, you wouldn't have this threshold requirement. You'd ask a question at a deposition, you'd say, did you do any of these things? Have you taken any photographs of yourselves over the last year? Yes, who did it? Do you have any photographs of the accident scene? Do you have any photographs of yourself at work? Those kind of questions, pretty normal, standard PI kind of questions. That would all be discoverable afterwards. You'd get hit with a demand and you'd have to turn it over.
Yeah.
How would this be different?
I don't think it would be different. I think that if the initial threshold requirement was met, a factual predicate based on relevant information, then a defendant could actually serve a tailored demand to that effect.
So is it maybe that all of us, all the courts, all of us maybe are just misinterpreting the height or how high this threshold is, and maybe it's just a matter of the specificity of the request rather than the requirement. The requirement is the same for all types, is what you're arguing.
I think you're exactly right. I think it's,
So you would argue that it's the specificity of the request, and that could solve some of these problems?
that's exactly right. The burden's on the defendant.
Okay, so what did they have to ask for? What would have made it specific?
I don't want to do their job for them, but.
Well, okay,
but I mean-
let's go with the hypothetical. You
Okay,
got a plaintiff who
hypothetical.
sets up and says, I cannot type on my computer without it affecting me severely, and it takes me hours to try and compose a sentence. Asked, did you compose something during this time frame? I don't remember.
I mean,
What can they ask for?
they can ask for text messages, they can ask for emails, they can ask for anything.
So how's that
they-
different from what they did here?
That's correct.
How is it different?
Well, they didn't ask. They asked for everything. They didn't.
And they didn't get everything.
Well,
They
they
got
asked-
some stuff,
Right.
or they got an order that would give them some stuff.
Why isn't the burden on you under 3102 to seek a protective order on the grounds of oppressiveness or overbreadth or burdensome instead of the other way around? If you get doesn't this happen typically? You get an overbroad request and you either negotiate it or you move for protective order.
Well, I mean, you can oppose the motion to compel, or you can make a cross motion for a protective order. I personally would have made a cross motion for a protective order, but I don't think it's fatal, to this case
The
because.
court here narrowed it and gave something substantially less than what was requested.
True, but I don't think
Why
that.
doesn't that solve the specificity problem?
Because the production of all pictures taken after the accident is too broad, at least in
Well,
my
how
opinion.
how does
And
that square with 3101I?
Liberal discovery,
No, that's A. I relates to photographs particularly.
because it wasn't, I mean, there has to be some, I thought that there has to be some factual predicate for the photographs. I mean, you just can't ask for all photographs. I mean, every family album that you have, or every picture that you've taken since the accident, is that discoverable?
But
I
is
don't
that
think
what
so.
they ordered? I thought it was any photos of her.
Any photos of her after
So a
the
photo of
accident.
her dog, say, would not be discoverable.
Well, I would think that if, under a properly tailored approach, that the
But
plaintiff.
under this order,
Under this order, I think that all photos taken after the accident
but doesn't it say all photos of her?
of, well, yeah, I mean.
Well, and then it was
of-
also further limited, not romantic, not nude, whatever, to protect privacy interests.
Right, right. I still think that's
I
too
mean,
broad.
the problem that I'm having here is applying 3101 liberally, whether or not all of this stuff will ultimately be admissible is down the road. The judge tailored something. How is it an abuse of discretion, what either the trial court did, and that's what I just don't understand, if that's the standard.
I mean, well,
I mean, different judges are going to tailor it differently, but we're not going to micromanage either at the appellate division or the Court of Appeals that kind of tailoring.
true. But I just don't think that, under these circumstances, this particular order was tailored to the facts of this case. With the exception, I mean, I think it's too broad. Just limiting it to non-nude photos and non-romantic photos and everything else taken after the accident is just too broad. I think the defendants have to, take some responsibility here for not tailoring their demands appropriately. And I don't think Judge Billings actually had her order was not specific enough.
I asked defendant's attorney, I'll ask you, do you think that we could, if we were so inclined, affirm what the appellate division did here, but make clear that defendant could serve a more narrowly tailored discovery request?
I mean, the defendant's free to serve this, I mean, as long as the note of issue is not filed, the defendant's free to serve more narrowly tailored discovery requests.
And that is the case now, discovery is still ongoing?
I don't know. I wouldn't think so, since this order was from 2015. But I don't think that issue's properly before this court.
Thank you, counsel.
Thank you.
Counsel?
I would just confirm that the note of issue had been filed, so withdrawing that would need to be part of the procedural mechanism. But beyond that, if the court has no further
Let
questions.
me ask you,
Yes.
if during the deposition, she's asked, did you use Facebook past X date? She says, I did not, even though I didn't, except to deactivate it 3 months later. Can you request for anything during that period? If she actually says, I never used it?
I think that would be, there would be a strong argument against disclosure in that standpoint.
Then you're on a fishing expedition, you have no basis to believe?
I think that would be a stronger argument for a fishing expedition, yes, with that type of testimony.
Thank you, counsel.
Thank you, Your Honor.